I'm pleased to present part 4, Cybersecurity and Privacy, of our Starting a Small Business series. So this is a primer on privacy and cybersecurity. In 30 minutes, we're not going to be able to cover everything that you need to know when you're starting a small business, but I think we'll get to the basics so that you can be cyber secure in your small business. So what are the first steps? What do you need to know? So first of all, consumers these days are demanding data privacy and data security. So data privacy are the rules and regulations regarding how you are collecting personally identifiable information, also called personal information or personal data, and the why. So it's all of those. How, who, where, why are you collecting this information, and how you are using that information, storing it, and sharing it. And you're also obligated to explain to the consumer who owns that information. Is it the consumer? Is it you? And what you're going to do with that information. So that's the collection part of the piece of the puzzle. Next is the security part. So you're collecting all of this information. How are you securing it? Internally, do you have limits on who has access to the information? Externally, is your system hardened? Are you able to prevent third parties from hacking into your system and getting to that personally identifiable information? And then what are your obligations under the various laws? And please, if you have any questions, put them in the chat. So there are a lot of compliance obligations, and they are very, very burdensome, I'm sad to say. So on the regulation side, one needs to be concerned with the state in which you are established, but you also need to be concerned about the other states in which you might collect information. So if you are running a website and you have a newsletter, for instance, or a blog or a vlog, or you communicate in any way with your customers whereby you're collecting their personally identifiable information, then you have to be concerned with, oh, well, where is this customer coming from? Is this customer just based in New York, or are they in the tri-state area? Or perhaps are they in Europe or in Canada? The minute you touch data that is from a citizen of another state or another jurisdiction or another country, we have to be concerned with the regulations that govern their residents. So just because you are in New York State or in Connecticut or in New Jersey or wherever you might be, you have to be concerned with the regulations of the residence locations of the consumers, and those are the consumers from whom you are accepting information. And these rules and regulations and requirements, they change regularly. So one part of our job is to make sure we understand the existing rules and the amendments. And sometimes, if there is a hack, you have to be able to produce that evidence trail. So your systems have to be built so that the evidence is there for you to easily access. And there are challenges here as well in your supply chain. So let's say that you are running a business-to-business business. First, you have to understand if the information you are gathering is also personally identifiable information, and you have to see if you have any contractual obligations to keep that information safe and secure in a particular manner via the contracts that you've signed in your supply chain. Then we've got the issue of cyber threats, which we'll get into a little bit more in this presentation. And then, of course, time and money. How much time do you have to spend on these issues, and how much money can you allocate to them? Last You have to train your people. If you have employees or even independent contractors that are going to touch this personally identifiable information, many state laws and laws of other countries require compliance training, and some even require you to designate a compliance manager. So, is everything I've said so far optional or mandatory? Well, in a lot of cases, it's absolutely mandatory. Governments, states are putting the onus on businesses to establish a much more secure and protect me approach to compliance regarding data privacy and cybersecurity. And if you neglect these legal mandates, you have an increased risk of an audit, sometimes penalties, litigation, reputation harm, and that could lead to a loss of customers. So it's important to pay attention to the legal requirements. So you may have heard recently that there is a lot of cybercrime. SolarWinds may come to mind. The government and many businesses, several tens of thousands of businesses, were hacked. There were vulnerabilities, and personally identifiable information was taken. Indeed, global ransomware causes $20 billion of damage. So this is a big business for people who know how to hack. And hacks actually occur every 11 seconds. So this is something that really needs to be put on the top of your to-do list. Now, where are you saving your personally identifiable information or the personal data that you're collecting? Are you saving it on a secure server that's behind a door and only you have the key? Or, as is sometimes more common, are you saving it to the cloud? So if you're saving that information to the cloud, one best practice is to take a look at the contracts that you have with that cloud provider and really understand who has what obligations. Are they indemnifying, which means protecting you if there's a hack? Are they taking responsibility because their systems were hacked? Or are they putting that responsibility on you? Who is required to indemnify whom? Are there no indemnification requirements? So if you're using the cloud and they're not indemnifying you, then it's your responsibility to come up with the money to deal with the cyber hack. So how do you protect yourself? How do you allocate that risk? One way is through buying cybersecurity insurance, which is now generally available, and depending on your circumstance, sometimes reasonably priced. However, there's a big catch with regard to cyber insurance. When you receive that questionnaire, you can't just go through, oh yes, I do this, oh yes, I do that, oh yes, I do this other thing. Because if you don't do all of those things and you're hacked, and it turns out that the hack was a result of you not putting and implementing the appropriate procedures, well, your insurance claim might be denied. So it's really important to make sure all of the parts communicate with one another. If you apply for cyber insurance, then you must make sure that all of those questions are answered properly and appropriately, working with legal and IT. So, cloud storage, it's a $150 billion industry. What are the risks? Well, unauthorized access, which is hacking, data breaches, which is not only hacking. You may have an employee that actually takes data away if you fire them, for instance. There could be leaks simply because your system is not hardened, and there could be thefts. What happens if somebody's laptop is stolen and it wasn't encrypted? You could have data corruption or loss if you're not backed up. And you could be working with insecure APIs, which are platforms upon which you could be building your website or mobile application. You could have misconfigured applications for storage. In other words, things weren't set up properly and therefore you lost data or data has leaked out. So what are your obligations if you are in New York, or if you're anywhere and you're collecting information about New Yorkers? And I emphasize that again. You could be sitting on an island in the Pacific and running your business. And if you're collecting information about New Yorkers, then you are subject to the SHIELD Act, Stop Hacks and Improving Electronic Data Security Act, which was passed last year and put in force in March 2020. And the focus of the SHIELD Act is actually not privacy, but security. So unauthorized access to or acquisition of New Yorkers' electronic, not paper, electronic records, where that unauthorized access may compromise the security, confidentiality, or integrity of private information maintained by a business. And the question that the law requires one to ask is, was the private information accessed or reasonably believed to have been accessed by an unauthorized person? So even if nothing was taken, if there was an attempt and your IT people said, uh-oh, our systems were challenged, well, then the law still applies, again, to electronic records only. So who is subject to SHIELD? Any person or business that owns licenses or for service businesses maintains computerized data that includes the private information of New York residents. So this covers everyone, an individual who may have this data, a nonprofit who may have this data, businesses big and small. And again, this entity that has the data of New Yorkers does not have to be located in New York or even conduct business in New York. The important feature of SHIELD and why the law was written this way is to encompass anyone who might touch the private information of a New York resident. Now, New York staged their definitions. They first started with a definition of personal information, which is any information concerning a natural person, which because of name, number, personal mark, or other identifier can be used to identify that natural person. And then they combined this personal information with another data element to create private information. And that includes the data elements of a username or email address in combination with a password or security question and an answer that would permit access to an online account. So what this means is your passwords to, and everyone's passwords to their accounts should be kept separate and apart from the location in which the personal information is kept. Because if a hacker can combine the two and get access, well, then you've got an issue. And if the personal information is combined with any financial information, such as a credit or debit card number, or biometric information. So the only exclusion here is publicly available information. So if you can go into a database and find out all of this information in a not an illegal way from federal, state, or local government records, then it's not covered and you can use that information and you're not subject to the provisions of SHIELD. So what happens? When would the obligations of SHIELD come into effect? Well, as I mentioned before, a computer or laptop or phone could be stolen, records could be downloaded or copied, fraudulent accounts could be created. So what IT is looking for is an indication that the information was viewed, communicated with, used, or altered without valid authorization. And if this happens, you are required to notify your customers that there was a breach immediately following discovery if the private information was or was reasonably acquired by an unauthorized person. So immediately, that is an enormous burden. So your systems have to be hardened, which means secure, and also designed in such a way so that you can satisfy this immediate burden. Now, how do you do this? How do you go about doing this? Well, the law also requires you, if you have the data of New York residents, to draft certain documents. And these documents are a written information security program, a cyber and information security policy, an incident response plan, and a business continuity and recovery plan. And if you were doing the right thing back in March 2020, then you had these documents in place, which was actually extremely useful when everyone moved to remote working, or almost everyone, due to COVID. Specifically, the business continuity and recovery plan. That document lists out everything that you need to know to move from a physical office to a virtual space, and how to deal with a virtual space. So your cyber insurance information would be there. Your landlord's information would be there. Your lawyer's information, your IT information, any information that you would need to run your business is put in one place in that plan. An incident response plan sets out exactly what you need to do, all of the steps that you need to take if there is a breach, or remember, a suspected breach. The cyber and information security policy basically tells your people, it's your training document. This is what we need to do. This is how we handle information internally. And not only private information, but confidential and proprietary information. And the written information security program is your framework for all of this. And again, these documents are required under SHIELD. Even for small business, the documents may not be quite as hefty for small business, but they are still required. And small businesses are fewer than 50 employees, less than $3 million in gross annual revenue, or less than $5 million in total assets. So the law asks, does the small business security program contain reasonable administrative, technical, and physical safeguards that are appropriate for the size of the business, what the business is doing, the sensitivity of the information the business is collecting? And now, if your business is in healthcare and you're already in compliance with HIPAA or high tech, or if you are in a financial services business and you're already in compliance with New York's financial services rules regarding data security, then your work that you've done already, assuming you have all of the appropriate policies in place under those laws, they automatically comply with SHIELD. Now, looking at your privacy policies, these are the questions that you should be asking. What information is being collected? From whom is the information being collected? So consumers, vendors, prospects. How are you collecting that information? Do you have a contact form on a mobile app or a website, or even via hard copy? Why are you collecting that information? What do you intend to do with that information? Are you going to send more marketing material? Are you going to share that information with partners, business partners of yours? Are you going to sell that information? How long are you keeping the information? And what intellectual properties, policies are in force? So these are all really important questions to ask in order to set up those documents that I just mentioned, including your privacy policy. If you have a front-facing website to the public, then you should have a privacy policy that explains all of this to your customers. You should also have terms of use, which are different from a privacy policy. So the terms of use, basically, most of them say, well, you're accepting this is the way I've designed my website and how my website or mobile app is going to work. So it's deemed acceptance, and that statement is in the terms of use. The terms of use will also tell you who is the intended audience here. If you have a business that is aimed at children, then you have to also comply with the Children's Online Privacy Act, COPPA. And you have to tell people that's what you're doing, and then you have an extra layer because you need parental consent. Terms of use also set forth intellectual property policies, including, well, are you accepting content from your consumers? And how is that going to work? Who has the responsibility with regard to that content and whether it's original or not? Typically, in order to be covered by the safe harbor, you don't want to take responsibility for that content. You want the content creator to have full responsibility for that content. Content creation. Are you, going to allow your consumers to do something with your content? Let's say that you are a children's book author. Are you going to allow fan fiction, for instance? Your terms of use would explain that to the public. We just discussed COPPA. Indemnification. Again, with content creation, you have a safe harbor if the content creator is solely responsible for that content and is indemnifying you. Now, from a practical perspective, the indemnification is only as good as the assets of the content creator, so you still have to be a bit careful. What representations and warranties, if any, are you making in the terms of use? Are you selling goods? Are you providing a manufacturer's warranty? If so, what are the terms of that warranty? Are you limiting liability? And lastly, DMCA notice. If you have a website that has any content whatsoever, the government requires you to have a DMCA notice that basically says, oh, I think you copied my work. Who do I contact to make a complaint? And that is required, and you're also required to have a DMC agent listed in the Copyright Office. Now, I think we're at 25 minutes, so I'd love to entertain any questions that anyone might have about the presentation. This is a complicated area. It's a lot of fun for me as an attorney, but not so much fun for our clients who have to comply with all of these changing rules and regulations. So Maggie, are there any questions for me?
Yes, there are. Thank you, Amy. We'll get started with the first one, which touches on what you just mentioned there. How do you suggest a small business owner keep up with the constant changes in regulations and compliance?
So I represent a lot of small businesses and solopreneurs and emerging companies. And honestly, most of them are using us as counsel because it's really impossible for a layperson to keep up with all of these laws and regulations and understand them. I mean, frankly speaking, we're required to take continuing legal education courses, or in my case, I teach them. And you have to be living this field in order to understand your obligations. And we understand the marketplace, we understand our clients' budgets, and we work with them because our goal is risk mitigation for them. Unless you enjoy spending your weekends reading up on all of these laws, I don't think that's a good use of your time or effort. It really is such a specialized area that you need some sort of professional advice in order to proceed.
Okay, good advice. Thank you, Amy. I see we have some more questions, and a reminder, if you have a question, you can use the chat box, or if you're on the phone, you can email info@savvyladies.org. Amy, the next question for you says, when starting my business, do I need to store customer information in the cloud, or are there some alternatives to that?
So you don't need to store customer information in the cloud. The point is that the customer information should be securely stored. So as I mentioned, if you have a server, what we recommend is that you have a server that's actually not connected to the internet. That's the easiest way of avoiding a hack. So you may collect the information online and then move that information to a secure server that doesn't have an internet connection. And in that way, you are avoiding a lot of problems. And once you move that information, you're deleting it from any online systems. Now, is that practical? If you are using all of that personal identifiable information to do a vlog or send out a newsletter or somehow continuously communicate with your customers or your clients, you may wish to just have a list that is accessible to you online of their email addresses. So that in that way you reduce the risk that the back end information, which is the financial information, anything else, any of those data elements, could be hacked and taken and used in an inappropriate way.
Okay, thank you. I'll move on to the next question, which says, if the only information I collect is for a purchase, and that's through my website, but I'm using a third-party credit card processor that's collecting the information, am I responsible for keeping that information safe, or is that third-party processor responsible?
Right, so this is where looking at your contract comes in. The responsibility is set out in the contract. Hopefully, the third-party processor says, oh, we are complying with all applicable laws. Not you have to comply with all applicable laws and you are responsible. So you have to look at the terms and conditions of that contract.
Got it. Okay, thank you. And I think this is the last question, which says, a question from the documents to be drafted slide. Would I need to hire a lawyer or legal team to create these, or is that something I can create on my own?
I strongly recommend that you don't try to create those on your own, or download them from some sketchy site on the internet. These are complex documents, especially if you are relying on them for the purposes of saying yes, yes, yes to a cybersecurity inquiry if you're getting cyber insurance. They're complicated for a reason. They're designed so that they comply with the SHIELD Act, and this isn't the kind of thing that you want or may even be able to do it yourself. And I'm speaking honestly. They're difficult documents to prepare in some cases. Yeah, and it's not the kind of thing you want to download from some sketchy site on the internet.
Okay, very good advice. Thank you, Amy.
You're welcome.
I believe those are the questions that we have. So Amy, I see you have your contact information here, which we will be sure to send in our follow-up email as well. And Amy, if anyone has further questions, they can contact you here. Is that correct?
Absolutely, and no charge at all. This advice is given freely, and please feel free to ask me questions.
Okay, thank you so much, Amy.
You're welcome.
I want to thank everyone for joining us today, and I want to thank you, Amy, for a really great presentation and for clearly explaining what can be a pretty complicated topic for small business owners. So thank you very much.
You're welcome. I enjoyed it. Take care, everyone.
Bye-bye.
Bye-bye.